you can also register resident welfare associations as a Section 8 company, a non-profit organization. You can also register under the Partnership Act.
Due to reasons, passed away. What are the legal ramifications, if I can call that, or what are the fiduciary responsibilities of these office bearers?
So the office bearers are governed by the bylaws. This is like a threat saying if you don't do what I want you to do, then I will not pay you. That doesn't generally work, or legally it's incorrect to, if let's say as a resident you want your management committee to make certain changes, then there is a way to approach. The approach can't be I will not pay you, I'm going to withhold because I'm not getting what I want. That's not how it works, because it's not about you, a single flat owner, but it's always a collective.
Say there is, a burst pipe that is in the common area in a shaft that is causing problems to the resident.
Right.
And they have repaired it, but it continuously leaks and it is flooding his bedroom or toilet or whatever. And the resident has complained to the management committee saying that you need to take care of this because I can't take care of it. And the management committee has not addressed it. Even after repeatedly telling the management committee, then what is the recourse?
So there are two issues here.
Okay.
Residents have to be very aware to not mix the issues that they are facing with maintenance.
Okay.
Because let's be honest, why is maintenance being collected? Because the association is spending X amount of money.
Okay.
It's not that the association is not spending money but collecting money from you. If that is a scenario, then we look at a different legal option. But generally, associations are collecting money because that amount is going out of the association funds, which means you have to pool into those funds.
Got it.
So that's a separate issue. Now, the scenario that you just mentioned is a situation where I, as an apartment owner, is facing an issue. I'm complaining to the management, they're not doing anything. I can claim damages in a situation like this.
Okay.
But I should not be mixing this with the maintenance. Because like I said, maintenance is an amount that the association is spending and you ought to put your money into that pool. You can't say, no, the basketball court is not functioning properly, therefore I'm not paying you maintenance. That's not how it works.
So you claim for damages that you are facing. So you have maintenance corpus, and there is also something called a sinking fund.
Right.
What is the sinking fund? Why is it needed?
So sinking fund is something, in my view, it's contractual in nature. Because a lot of agreement to sell mentions, and in your consideration that you pay for apartments, there is a corpus amount that the builder is collecting. And in these clauses, you will see that the sinking fund is being collected for X purpose, and the balance will be handed over to the association. Now, this is a great clause because this comforts a lot of new associations that are coming in. Because they have a corpus that they can bank on without thinking about where do I start. I don't have a corpus. Tomorrow there's an emergency that happens and how do we bring in that spend, right?
Got it.
So it's a financial security.
So that means that once a society is formed and the society takes over, which we'll talk about next, the sinking fund also needs to be transferred to this society.
Yes, contractually that's how it's designed. The purpose of a sinking fund is a corpus amount that the builder has collected, which they will then hand over to the association when the association of residents takes over, so that they have financial comfort in terms of how to move ahead with their functioning. Now, what is the issue that we see? That a lot of builders deduct some amount from the corpus fund, saying that, and also it's not just for the comfort of the association, it's the comfort of the builder. Sometimes the builder faces difficulty if he's, so generally most builders say, I'll give you 1 year of free service, so 2 years of free service. It's technically not free, it's collected in some manner. But let's say if the builder, because of failure to hand over on time or due to some other issue of not being able to hand over after this 1 or 2 year period, if they have to continue running, they will also bank on this corpus fund. Right? And those are deducted and then handed over to the association. So it's beneficial for both. But of late, I've also been seeing that a lot of builders are not collecting this at all. They're like, I don't want to deal with this issue of
So it's more of a headache than anything.
So a lot of people are choosing not to do it. So it's purely contractual in that sense of how they want to hand over. But you can't collect sinking fund, contractually also avoid paying this amount, because you will have to showcase either how you spent it, what was the purpose you collected it for. So yes, if you want to legally recover this amount, depending on how your contractual clause is constructed,
you can take a look at it. So we've talked about a lot of different topics, and one of the most important things is after the society is formed, there comes a point when the society takes over from the builder because they need to take ownership. At this juncture, there are a lot of legal tests or legal checks that need to be done from the buyer's side so that they are taking over a healthy baby. Do you want to take us through what these are and what one needs to be aware of?
Right. So, in law, there is no definition of a handover takeover process as such. But this is like a company being acquired,
Okay.
or where an investor is investing into the company and they want to do a complete due diligence. It's a very similar situation. I think awareness, the first thing is at the time of handover takeover, the residents have to be aware of the property. Now, it may not be very prudent for someone to just do a takeover, sign off some documents without being aware of what they're doing. So, in my opinion, it would be best in a legal situation, the first thing is to be aware of your documents.
When you see documents?
When I say documents, everything from land to the building plan and the sanctions and all the permissions and everything. So it's exactly like how an audit that you would conduct of a title report or a title search that you would do when you're purchasing a property. A very similar structure has to be adopted by the association to look at the whole building in terms of land as well as whether the building is built and if all the necessary permissions have been obtained. So first is to be aware of every single document that you are taking over, which will also help you understanding your own land, which is very important. Your own land and building. This understanding for somebody who's taking over is very essential. Number two, be aware of your land as well and your building, which is something that you do, right?
Yes.
What do you have in it? What are the structures that are right? What have gone wrong? These are essential things that you need to know. Even though this is not legal per se, but this education is very important because this, when you read it with the documents that you have, is a great understanding that you have of your own property. And when this comes in, then comes your financial aspect, wherein if there is a sinking fund, then how are we going to take the transfer? And also understand your bylaws during this process, because now you will start running your associations. And when you start running your association, you need to be aware of what the rules are, which means that does my bylaw allow me to collect monthly maintenance, or is it quarterly, or am I flexible enough to design how I want to collect? Can I collect maintenance in advance, or is it prorated later on, etc.? So how do I call for meetings? This kind of understanding is very essential before you start running your association. So in terms of legal, what we look at is we do a complete check of all your land documents, all your building documents, give you an understanding, a report of your own building, and then tell you what are the documents, original documents of the builders to hand over to you, and what certified copies you need to collect.
Can you name a few examples of what these documents are? You don't have to go through the whole list, but top three.
I think conveyance deeds, like all your previous sales, gift, JDA, sharing agreement. So the whole lot of how the transfer has happened, documents related to transfer of land. And then comes your construction, your permissions, where we look at sanction plan, then we look at your occupancy certificate, then we look at a whole load of permissions given by various authorities in order to construct this building. Necessary sanctions have been obtained. If your lift permissions are in place and STPs are in place, at least you have documents to support all your common areas. That's something that we look at.
I'm sure somebody would ask this question because there's been a case recently where there was a forged occupancy certificate, right?
Right.
We talked about this briefly last time
I
also.
remember, yeah.
So there is only to a certain extent that this can go through, because as you said, you provided this information and you're going to take it that this is correct or this is true to its nature. What does the recourse that a resident has if tomorrow the occupancy certificate itself is forged?
Right. So, of course, there are legal ways to approach this. One is in a situation of photo that you're talking about. We first do a preliminary check based on photocopy documents. And then, while the handover process is in place, we also check originals. Now, if somebody's forged a document, it may be difficult even for us to understand, or any lawyer for that matter. It's honestly a chance of luck. Like if I'm able to suddenly see, and then it can be disputed. Suppose I say, I think this doesn't look original. Some people could say, no, I think it's original. No, OC cannot be, right? Unless such a scenario comes in, you'll always, the presumption is that it's original.
It's original, correct.
So in a situation like this, what do? You have legal recourse. If your property is a RERA registered property, then you can take recourse under RERA, or you can go to the police because it's a forged document, it's a crime under law. So there are many legal avenues for you to approach this. Yes, it's difficult. It's a difficult situation. Obviously, when there is a problem, it appears to be difficult. But I feel like there are enough solutions which people need to start exploring. And the one thing that I see in my experience is everybody is very worried that it's time consuming. I may not get results. I don't deny the fact that it's time consuming. Of course, judiciary is really, there is a backlog, and it's not just an issue of the judiciary, it's just how the structure is. It's everybody's responsibility to make things better. So there is an issue in that sense of time consumption, but that doesn't mean you don't take action. Take action, continue with your life, something good will come out of it.
Definitely.
So like I said, just coming back to where I stopped, is we will do a check and we will see whether the documents, originals are being handed over, certified copy, etc. Now, generally, after this process is over, there is a sign-off. Either there's a handover agreement or some kind of an understanding where we say that all these documents have been handed over, and some kind of a agreement is signed between the parties so that they can take over. Now, it is essential, or it's important to understand that you may not get 100% of your documents. Some small documents may have been missed, but that you should leave it to your lawyer to decide, is it okay that we move on with the documents that we have, or are there some critical documents that are being missed? So all this is a process that we look at when it comes to handover.
You're talking about
negotiables and non-negotiables.
You're talking about legal documents.
Legal documents.
Even in terms of technical documents, you should leave it up to the technical auditor to tell you whether they can go ahead or not. Yes. Okay.
So this is how we close our handover process. We look at the documents, we look at the originals, we sign off with an agreement. So the process is a good 3 to 6 months, depending on the size of the apartment.
So you mentioned negotiable and non-negotiable. So you're looking at the priority and the severity of the document's necessity, and then you will say whether it's okay or not. There could be a certain scenario where they can generate a new document and give it, and then you can say, okay, fine, this is fine, then you go ahead. We've talked a lot about the laws, we've talked about what the process is. Let us, towards the end of this conversation, look at a dire situation where the management committee says, okay, we're going to take over this, but the builder, for whatever reason, says, I just don't have the documents, I won't give it to you, or I don't even want to do the handover takeover. Then what happens?
Right. So it's a very rare situation that the builder wants to continue maintaining the association, because for him also it's a burden.
Yeah, they may not say that forever, but I want to do it for the next X number of years. Or,
right. So I think the situation that you're looking at is where there is some kind of a difference of opinion, or there is a dispute in terms of documents. Then how do you approach it? I would say go ahead and do the takeover, because you need to be in control of your association.
Can we do a contingency contract and say, fine, I'm contingent?
If the builder is going to sign such a contract, yes. I'll be very surprised if somebody comes and signs a contingent contract of this nature, saying that you take over and then over this period of time, I will give you these documents. It's a very rare situation. So in a situation like this, when there is a difference or a dispute in terms of not handing over documents, or let's say the builder is not even responding, then what do? My advice would always be take over. Start running your association. It's very important for you to be in control. Don't say, I will not take over because documents are not given to me. It has to happen parallel.
The concern is there is a audit that happens. Audit findings come about. There are many points that need to be addressed by the builder.
Correct.
The builder says, no, you need to take over now, and then I will look at it. But if I take over now, I have taken over a sickly baby. I have to then pay for the medication for this child. Whereas if I was to say, okay, I'm going to take over contingent on you addressing all of this over this period of time, then there is still some amount of recourse or some amount of leverage that the management committee has with the builder. Because there is still some skin in the game for the builder.
So that's a situation where the builder agrees to continue maintaining your apartment. The situation that you're talking about.
No, what I'll say is, some of the discussions that we've had will say that we will deem the handover takeover complete, contingent on X, Y, and Z being adhered to and met in this particular time frame, whereas we will take over running the society using our own FMS or an FMS provided by you. We will have our own estate manager. So we have control of the situation, but there are these lacuna that have been identified that needs to be addressed by you because you promised it.
Absolutely. So what you're talking about is a situation where there is communication that is ongoing between the association and
Yes.
the builder.
Yes.
Simultaneously, the association maintaining. That's
Correct.
pretty much my point as well. That you keep the communication going, saying that these issues have not been addressed. But what happens is, let's say there are certain issues which the builder has not addressed. Can you, or how long are you going to sit on that issue? Let's say it's a situation where the STP is not functioning. How long are you going to be in a property where the STP is not functioning until the builder comes in, rectifies the STP? I would say in such a situation, please give a timeline. There should be any contingency should have a timeline saying within this period I need you to resolve it.
Correct.
And if that problem is not resolved, you may have to initially invest your funds, rectify, then claim damages from the builder.
Got it.
That should be the process. I don't think residents or the association should sit on a problem for a long time, because ultimately you have to understand that this is your property. Yes, the builder may not have done a proper job. There could be some defects.
This comes back to the original discussion that you had, that it will take time, but there is recourse at the end of the day. There is, and you do get a solution. Yes, you will have to run.
You have to act.
Yes.
You can't say, no, I will wait for the builder to come and rectify, because that's not going to happen.
Going to happen. Yes, because it is not in his current interests, but it is in the owner's interest, and they need to follow. Fantastic. Well, thank you very much, Sneha. Very lovely talking to you.
Thank you for this opportunity.
We will be talking a lot more on a lot of different topics, and hope to have a series of discussions with you regarding very interesting topics with regard to law and property, maybe even 15-minute, half-an-hour conversations, so that people are able to get updated on the various things.
Certainly.
Thank you.
Thank you so much.
Thank you.